Good. All right. Good evening, everyone. It's 6 o'clock, and I think we will get started and call the meeting to order, the meeting of the Central Pennsylvania LERA chapter. We are very excited this evening to actually be joined by two members of the national group this evening. We have Bernadette and Emily that are joining us this evening. And on behalf of our chapter leadership, I would like to welcome everybody. We are hoping that at some point we'll have the opportunity to meet face to face. We always enjoy those meetings and the pre-meeting that occurs right beforehand typically, but we do welcome you all this evening to our session. What I would like to do is go around and introduce our officers. Actually, I'll let them introduce themselves and then I will jump back in. First, I'd like to have Rob, go ahead.
Hi, Rob Barron. Happy New Year, everyone. I'm an arbitrator and mediator just outside of Philadelphia.
Very good. Kate, you may go ahead.
Good evening, everyone. My name is Kate Rowe. My dog behind me is Nova. I am a shareholder with Stroke Off and Cowden, and we do principally labor side labor and employment law. Good to see everybody, albeit virtually.
Very good. Chris, you can go ahead.
Chris Rupno, happily retired for about 2.5 years now from PSCA Research. Happy New Year.
Very good. I'd like to introduce Joe.
Hello, Joe Canamuccio. I'm from Harrisburg. I work at PSCA in the legal department. Good to see everyone.
Very well. All right. What I'd like to do is go around and try and have folks, now my screen is kind of limited here. So I'm going to try and call some names out. And then once we get through the list of individuals here from the group, I'm going to pop back in and introduce our speakers for this evening. So the first person here, it's Tom Leonard. Could you go ahead?
Hi, everybody. I'm Tom Leonard. I'm an arbitrator from Harrisburg, Pennsylvania.
Very good. Scott, go ahead.
Hi, I'm Scott Stedgen. I'm a labor side attorney for Kuhn and Gephardt.
Very good. Thank you. Jim, go ahead.
Did you say Jane?
Jim Dugan.
He'll have to unmute himself.
Okay, go ahead. Jim Dugan. Okay. He kind of disappeared. We'll go over to Larry and then we'll come back.
Hi, it's Larry Cheskowitz. I'm an arbitrator and conciliator out of the Allentown area.
Very good. Thank you. Jane. Now we'll go to you, Jane.
I'm Jane Rigler. I work as an arbitrator and mediator, and I live in Carlisle.
Very good. Mark, go ahead.
Mark Lamont. Hi, everyone. I'm an arbitrator out of Hershey, Pennsylvania.
And we have Kimberly.
Hi, Kimberly DeVanzo. I'm with AFSCME Council 13 Grievance and Arbitration Department.
Nothing.
Very good. Welcome. John, go ahead. John Alfano.
John Alfano, arbitrator in Leonardtown, Maryland, and Scranton.
Very good. We'll go back to James Dugan. Go ahead.
Yeah, Jim Dugan, Pasco liaison and consultant out of State College.
Very good. Good to see you, Jim. Mary, please go ahead.
Mary Tricia Metzler. Is that who you're referring to?
Yes, please.
Hi. Yes, I'm Mary Tricia Metzler, and I'm an arbitrator and mediator, and I'm in Westchester, Pennsylvania, and do work here and there and all about.
Very well. Welcome. Deb, thanks. Please go ahead. I think, Deb, you're on mute.
Am I heard now? Okay. I'm not at my best. I had a very bad accident in November, and I've just gotten out of rehab after weeks in the hospital and rehab. So I'm not exactly at my best, but I'm an arbitrator and mediator, and my office now is in Mechanicsburg.
Okay, well, thank you, Deb, and get well soon, please.
Thank you.
Gary, could you go ahead, please?
Hi, my name is Gary Kleffer. I'm an arbitrator and a mediator. And I live in Cincinnati, Ohio, where the Super Bowl champion will be, Super Bowl trophy will be on proud display in the very near future in Cincinnati.
Very good and welcome.
Okay.
Lanny, could you introduce yourself?
Did you say Lonnie? I'm sorry.
Yes, Lonnie.
Hi, I'm Lonnie Lounsbury, and I'm a labor relations specialist with the Postal Service.
Very good. Welcome. Liz Kelly.
Sorry about that. Yeah, I'm here. I'm Liz Kelly. I'm an attorney practicing out of Bethlehem, Pennsylvania. And FYI, I was born in Cincinnati.
All right. Very good. We have Josh Grubbs.
Josh Grubbs. I am a Director of Labor Relations at APSCA, the Association of Pennsylvania State College and University Faculties, and I am not a Bengals fan.
Okay. We have Sarah Miller.
Hi, I am also with APSCA, Director of Labor Relations.
Very good. We have Robert Gray. Is Robert there? Okay. We have someone here, UNHCR. Okay. Not sure who that is. We have
the UN High Commission on Refugees.
Okay. Very good. We have Stacy Hastings.
Good evening, everyone. My name is Stacy Hastings, and I work for the Bureau of Mediation as a labor mediator.
Very good. We have Marlena Lang.
Hello, everybody. I'm Marlene. I'm the director of horses at West York. I apologize. I'm taking care of my horses at a barn.
Very good. Did I miss anyone? I think I've run out of names on the screen that I can see. Is there anyone that I have missed?
Ezio Bercini.
Oh, thanks. Yeah, I'm here in Bethesda, Maryland, an arbitrator, Ezio Borcini. I don't know why my video is not working. It's turned on, but if anybody has any suggestions, I could use some help.
Is there a
Do you have a little
possibility-
screen?
That's what I was thinking. On top of your screen, maybe if it's a laptop, there may be a cover, a lens cover.
The camera's on. There's no cover on it, and
Okay.
the video says it's in use. So I don't know why. There must be a technical reason for
Is it a docked laptop?
No, it's a desktop and it's a Logic camera.
Okay. Wow.
So you will be deprived of seeing me today, and maybe that's a good thing.
As long as you can assure us you're not an imposter, we are okay.
Okay.
All right. Well, very well. It was great to have a chance to go around the screen here to have folks introduce themselves, and we were very excited about the great turnout that we've had for our meeting. As you well know, our topic for this evening is social media in the workplace. And this evening, we are actually very fortunate to have some great folks presenting today. I had the privilege of meeting Michael Miller almost 3 years ago to the day when I started in the Susquehanna Township School District. He was on board as labor counsel for our school district, and I've enjoyed every moment of working with he and his team. And he brought some esteemed colleagues with him this evening that are going to be presenting. And I'm going to turn the program over to them. I think just as a disclaimer, I know that early on, there was something that came across the screen to remind folks that the meeting is being recorded, but it is being recorded. To take questions this evening, we will take questions at the end. Please raise your hand. You may raise your real hand or your electronic hand. We'll take hands either way, and those questions will be facilitated as we go through the program. So at this point, what I would like to do is turn it over to Michael Miller.
Well, thank you, everyone, and thank you very much to both Emily and Bernadette from LERA World Headquarters or whatever, and to the officers of the LERA chapter in Central Pennsylvania. The last time I was privileged to speak in front of the chapter, I got a coffee mug. So, I mean, I'll do anything for a coffee mug. So that's, you know, when Mark called and said, look, we need some content. I said, is there a coffee mug in it? And sure. So I'm joined tonight with two of my partners. First, Tricia Springer, who is in this somewhere. Eventually, you'll see her dog Charlie, who tends to show up during these things. Very large black lab who has much to say on social media. Tricia is a summa cum laude grad of Widener University, but before that, she was a licensed physical therapist. So in our office, she does about two different things. One, she is an excellent lawyer on the management side in the public and private sector, but as my spine continues to devolve, she provides other advice in a different forum. The other person is that many of you may know is my law partner, Renee Meyers. Renee and I have been practicing together for about 20 years, longer than she would like, I think, to admit. We joined Reed Smith years and years ago when I went to Duquesne and she went to Pitt, and made a mutual pact not to ever refer to our law school years. Like Tricia, Renee graduated #1 in her class in law school, and I graduated. And so what I think that we're going to try and talk about is kind of what we've learned about social media in the workplace, because this is coming to us in a bunch of different directions. So I'm going to try and do some of the narrative. Renee and Tricia are going to do some color commentary. We're going to talk a little bit about the end about the right to know law and its impact on social media, because we're seeing that more and more as well. Let's jump into our topic, assuming that I can figure out how to work this. There we go. Right. So there's an unbelievable amount of social media. I have 3 teenage daughters, and if I didn't have social media, I'm not sure that I would have any opportunity to speak to them at all. I will say that when we did a survey at Deckard Siemens about the use of our systems and the use of social media, #1, site visited, kind of surprising to me, personal banking. #2 is Facebook. #3 is Amazon, and sometimes they flip-flop, and then you kind of go from there in terms of how we do things. And the concern that we have about social media is kind of emphasized in a quote that we've used a couple times, that a lie can go around the world before the truth can put on its pants. And it's actually a quote we put in a brief that we filed with, Tricia and I filed with the Supreme Court, involving a PennDOT employee. And I just want to illustrate the point about the ills of social media in the workplace. Tricia, can you give us a little bit on that, the case that we ended up trying in front of the Supreme Court involving the PennDOT employee and the, well, I hate to spoil your thunder, but kill all the kids on the bus, which really was what she said.
Sure, yeah. An employee for PennDOT was posting on her personal Facebook page. But on that page, she had, where you can put the work, who you work for. She had indicated that she worked for PennDOT. And in fact, she worked in the specific department that sort of addressed these issues. And she was in a group. It was a closed group, but it was a very large group, thousands of people. And there was a post that she put about a school bus cutting her off. And she said something about how she didn't care if she would kill those babies. And after posting something so terrible, people started commenting on it, and she stuck by this atrocious comment and continued on in the comments saying awful things. PennDOT found out about these posts because they were so atrocious in certain people's opinions that they actually reported her to the employer, and they were able to, reach right out to them because she identified herself as being employed there. After PennDOT, received these complaints, they did an investigation and ended up terminating her. And then it went through civil service, up to the Commonwealth Court. So civil service originally upheld her termination. The Commonwealth Court overturned the termination, finding that her speech was protected by the First Amendment. And then it went to the Supreme Court, where we filed an amicus brief, and they ended up reversing the Commonwealth Court and upholding the termination based on, the lack of public concern and the, manner, mean, and method of her speech.
This gives a prime example of how you could say something like that in a cafe, in a coffee shop, in a bar, and it would have no impact. But in social media, your footprint is there forever, and it happens. The stats show us that American workers waste approximately 2 hours a day on the internet. I think that's an underestimation based on my own personal practice. Trust me, I'm paying attention during our conference calls, mostly. Social network and iPhones are a significant issue. Renee and I have handled several cases recently where, these things, the phones, are going to kill us because we have hourly workers who are working off the clock by taking phone calls, texts, and emails at home because the boundaries of where work occurs anymore no longer stops when you leave the office. And those people are on the clock. And even though a text here or a file there, where's this file? Where did you leave that thing? May not add up to much. We're seeing more and more claims, or more and more threatened claims, by using work-supported media to, or township or borough or school district supplied phones where people are hourly and they're working. We also see a great deal of fights that would normally be fights in the parking lot, or fights by the copier, or fights by the water cooler, if we have water coolers anymore, that are spilling over to Facebook, that are spilling over to Snapchat, Instagram, or whatever platform that you're on. And people magically believe somehow that because I didn't send that message at work, and even though it deals with my work colleague, that there's no connection or nexus with work, and therefore I'm home free. Not so fast. These are the things that we see that we deal with regard to social media at work. Obviously, privacy claims. Tricia will talk a little bit about, under the right to know law, someone has a constitutional right to privacy. So there's some limitations on what actually can be provided. We see cyber stalking, all right? So, it's not just the awkward person who stands over your shoulder, which is kind of the old way of how Renee and I grew up practicing harassment law in the workplace. But now that you can do it by a keyboard, it's extra creepy and extra concerning. Pornography and sexting, listen, I talked to our IT person. We have a 400 lawyer law firm and probably another 300 people. And I said something to the IT person to prepare for this speech, and the IT person said, let me just cut you off. Yes, we can see all of it. And yes, it's disgusting, right? Disparate treatment, tortious interference, damage to both companies and to municipal employers. One of the issues in the bus case that Tricia was talking about is, the damage that this text what had on PennDOT, and on the reputational damage. Look, I mean, we're in the middle of winter, so reputational damage to PennDOT is a shaky thing, right? As my axle and my suspension keeps getting crushed by potholes. But there was a real concern about reputational damage and these kind of issues. Hostile work environment, everyone knows the case law on that. That has to be based on the suspect classification, but it can be taken from disparate effects from different employees. Renee and I started out years ago with, kind of the case from Pico in Philadelphia with the noose in the locker. And now you can do that online, making it that many times worse. And if my recollection of those Pico cases, which were kind of the forefront of a lot of hostile work environment cases, those cases involved things that happened to other employees, which were aggregated to the employer's general feeling about people of color in that workplace, or women, or people with disabilities. Renee, we've seen a fair amount of this kind of stuff.
Yes, and I think what this highlights is all of the kind of scary things that are out there when our employees are out there on social media and the internet and using their devices. But we also need to understand that, as Mike previously mentioned, social media can be a good thing in how you run your business and how we communicate with each other and how we get things done. And even when our employees are out there doing bad stuff or creating risk for us on social media, there are a lot of limitations on what we can do as an employer to try to counteract that. So we're going to
let's talk a little bit about retaliation claims. Obviously, for any of us who have done this for a while, you can lose the underlying discrimination case under the McDonnell-Douglas cases, but on the other hand, lose the retaliation claim. And let me give you a perfect example. We've handled cases where somebody was not discriminatory, that the person who's alleging discrimination really couldn't make out a prima facie case at the end of the day. However, the minute the person got the case, they texted or sent an email saying, how can I, send this person to East Siberia or whatever, cut off their overtime or do this or do that? Because let me just tell you something. The internet was invented for employment lawyers to have continued employment. It's a little known fact. And the second, that's how DARPA, that's what the Defense Applications Research Agency did, is just to create work for us. But secondly, and more importantly, all of us, or at least me, text and or email things that we would never say to people's faces. Now, in the old days, we could get away with it. Now, people think that if you text something, you hit send, that it goes somewhere outside of Pluto or wherever, and that it's never recoverable. It's always recoverable. It's always recoverable. And in the old days, you could put somebody up in front of a jury and say, did you say that? Now, somebody blows up happened to me last night in a school board hearing where somebody sent a text, and it became the significant issue. We're going to talk a little bit about organizational rights, which I'm concerned about with regard to a lot of the things that we deal with. Obviously, there are also limitations on what we can do. So the concern that Tricia and I talked about with regard to the mix between the First Amendment in the public sector whether or not somebody has the right to talk about a matter of public concern versus a matter of private concern, and where does that line go? And here's another question that I don't think the courts have addressed. Tricia, I'd ask you to jump in on this. I don't think the courts have addressed the virulence with which an opinion can get across numerous platforms through social media that didn't used to happen with traditional forms of communication. And I think we see courts catching up with that. Fair statement?
Yeah, it's definitely something I think the courts are looking to consider when they're looking at, balancing the importance of the speech, and comparing that to the employer's interests and whether or not it's outweighed. And I think the rapidity with which that speech can spread across the internet is something that, is a factor that they're weighing and making these difficult decisions in these cases.
So couple kind of basic laws that we wanted to cover just to remind everyone about these because they keep coming up. One is the Electric Communication Privacy Act. It generally prohibits intercepting wire, oral, electronic communications, email, internet use, and all of that kind of stuff. The big exception in that statute, and the big exception that people need to keep their eye on, is that if you're using an employer's system, there is a consent or an implied consent in the ability of the employer to look at that. That is an issue, and I just want to pick up on this, maybe get Renee's comment on this. When you log on to the system at Eckerd Siemens, there's a box you have to click that says, I understand that I can be searched at any time for any reason, even if we don't like you, Miller, or whatever. And that happens all the time. And one of the reasons I like that more than anything else is obviously one of the biggest issues that we have in any case is proving there's a rule and somebody knows about the rule. In this particular case, it makes it clear that you know that you are consenting to the use of this. But what we're starting to see more and more are people bringing their laptops and their own devices and their phones to get on our platform, to engage in social media and hook into our Wi-Fi. What we're going to start to see are whether or not those devices and stuff that comes from those devices, which are private, but are hooked into our Wi-Fi system, can be the basis for discipline or disciplinary action. Renee and I think both believe that once you decide to log on to our Wi-Fi, the stuff you send through our Wi-Fi, what you hook up to, and the fact that this could bleed over to maybe things that you don't want to be seen are an issue. Renee, your thoughts?
And we see that a lot with organizations, with employers, with school districts, which is, we might have a bring your own device policy, but if you do bring your own device, there's going to be different things that you're going to have to consent to be able to hook up to our Wi-Fi or to utilize the email systems. And a big part of that is always going to be consent. You're going to consent that, the servers still belong to us, that you agree to abide by our policies if you're going to connect to those servers. And you also consent to any search of what you do, communications you send, communications you receive, searches that you perform, websites you visit. So that's why we always counsel everyone to make sure that you have good policies in place and that the individuals using those systems are aware of those policies. And that could be something as simple as, like Mike described, that when you have that login screen, you get the warning, you get by clicking here, I'm consenting to these policies.
So the Communications Privacy Act has kind of broad exceptions, things that are readily accessible to the general public. That's an exception. You can look at that. Interception or disclosure in the ordinary course of business. And again, what we've talked about, prior consent to intercept by using our electronic use documents and things like this. The other thing I would just comment on, or have Renee comment on, or Tricia, is as we see people work from home, we see a couple things. One is some stunning wardrobe choices when people Zoom from home, me being the biggest offender, but also we've seen a couple employees get in trouble for, again, hooking their device up and what they're doing either in the background or using that platform. Renee, that we've seen that a couple times.
Yes, I was going to say we actually dealt with one where it was a Zoom call and somebody had shared their screen. And we all know when we've tried to share a screen that sometimes the screen you're intending to share isn't what pops up. Instead, you get your desktop or maybe another document or your emails come up first until you figure it out. And in one instance, there was a file folder that was visible on the workstation that had some inappropriate, alleged inappropriate content contained therein that was visible to others on the call. So, you know, the question becomes, was it a work computer? Was there something actually inappropriate on there? And the individual who was using the system had consented to a search of that system, which the employer then did conduct.
So the Stored Communications Act, another federal statute, does prohibit access to electronic communications, and your violation must be knowing and intentional, or exceeding the permission under the act, or disclosure of those things. But it does exempt things, again, where it flows through our system with consent and so on and so forth. Why that electronic use policy is so important for employers, and if you represent employees, why any ambiguities in the electronic use policy can certainly be construed against those kind of situations. This is an issue, I keep this case on, it's kind of an older case, the Hawaiian Islands case. This was a case where somebody violated the Stored Communications Act, an executive for the airline, where they got on the employee/pilot's personal password protected site because, you know, his password was 123 exclamation point, exclamation point, exclamation point, exclamation point, and everyone knew it. And other pilots gave that up, and you know, the executive said, "I'm really going to nail this guy. I'm going to get in." Anytime you're talking about somebody's password, even if they access it through your system, if you're then entering a password that you guess, you know, or it's on a Post-it on their computer, and you use it to get in, or you open their desk drawer, you're going to be violating the Stored Communications Act. But you would be surprised. There are two things that kind of surprise me these days. One is the number of calls we've gotten about people who have taped either Zooms without consent, or who have taped phone calls without consent, because really it's a good idea. I mean, we haven't learned from Watergate that taping phone calls is you know, probably a bad idea. And Pennsylvania is a two-party consent state. And so that's a significant issue. So anytime that you're doing something like that, accessing something, I think there are a number of states now, I think Maryland is one of them, and there are a few others. Renee, you and I have talked about this, that have laws that say you can't require an employee to give up their Facebook password as part of their employment hiring.
Yes, we saw this trend a couple of years ago when I believe that there was an allegation that went viral that an individual during a job interview was asked to basically hand over their social media passwords so the individuals doing the hiring could log in and check and see what they were doing on their private social media pages. After that, there was this push at various local municipalities as well as some states to pass laws to prohibit that conduct. And, you know, for a variety of reasons, and we'll get into that a little bit later, you know, sometimes it's good to not know what you don't know about people that you're interviewing. There's that balance between doing the reasonable background check search and then getting into something that somebody does in the private confines of their home or their locked, you know, password protected social media sites and emails.
So the kind of the leading case on or at least one of the leading cases from the Supreme Court, and I want to say it was a Breyer decision, so it had 15 subparts and 32 balancing tests. but was this case Jeff Kwan versus Ontario, California. Really simple case. City provides pagers. Took a while to get up through the system. City provided pagers to police officers. They only paid for so much a month. After that, you were supposed to pay the excess. And I have 3 teenage daughters. I understand what an overage is in a cell phone account. And the city audited this guy's use because he had sent 1,000 texts in a month, about 500 to his mistress and 500 to his wife. One day he messed that up, please get a standing rib roast to his mistress and something more scatological to his wife, and his wife figured that out. And the audit revealed that the number of texts meant that he was doing something inappropriate. He was disciplined. Interestingly, the Ninth Circuit reversed the finding in front of the employer, because this is an employer device on an employer paid data plan with the employer's rules and a reasonably good policy, but it exempted this idea of we're going to audit your use. Not only the officer, but his wife sued for a violation of their privacy rights, a little bit under the penumbra of the Ninth Amendment, along with and the Stored Communication Act. I can assure you that my spouse would not be joining me in that lawsuit after she read the text, but hey, and the Supreme Court said, look, he had a reasonable expectation of privacy in the text messages. The search of the message was a search, potentially Fourth Amendment issues, because we're talking about a public sector employer, that it was a reasonable search under the circumstance and had a reasonable purpose, and that therefore the employer had the right to search the system. Kind of the outgrowth of Kwan has been the desire of Renee and Tricia and I to look at your computer use policy to update every possible definition of platform and/or device, because this is where the analysis starts, right?
One of the things though that came out of that case, and that it's important to remember, is that the audit was just about the number of pages and the overages and whether or not they were personal versus work related. And so there's a difference between confirming whether or not an employee is using the system for personal use versus work use. And once you make that determination, you got to stop reading. You don't get to read all the gory details of each individual email message to the spouse or the mistress just because you're auditing personal use versus work use. Now, if you had complaints of harassment or sex discrimination, etc., then the search would be different. You'd be searching for something more, the content. So you have to be careful about the scope of your search when you're going in to look at what's happening on social media, on pagers, on cell phones, text messages, etc.
And we covered this concept before, the idea that somebody does not have a reasonable expectation of privacy, where you hook up to the Wi-Fi and you have a good electronic use policies and so on and so forth. In this particular case, same kind of situation where you have a work at home computer, which I am working on in case the IT lords of Eckert Siemens are watching. I'm doing work. Thank you very much. Again, no reasonable expectation of privacy. One of the kind of the sharp lines that we look at when we talk about both electronic use and social media is it's shocking how many people talk to their attorneys on work computers. If we are in a situation where somebody is, if we're doing an audit or we're looking at someone's social media use or email use in the workplace, the minute we talk about attorney-client privilege, that's a stop. Even though it would be fun to read those, the privilege still exists. You set up a privilege log and you kind of stop there. And the cases are pretty clear on that point, that they're not going to courts are not going to agree to a waiver on that issue. It's Renee's favorite subject, internet application screening, right? Everybody Googles everybody else. And I will tell you that for a number of the employers that we work for, it is a revelation that it's possible that something on the internet may not be true. Renee, help me out.
Right, because Bill Gates is going to give you $1 for every message that you forward. I know it because I saw it on the internet. Obviously, we all employers have some obligation to do a reasonable search into whether or not somebody is being truthful on their application or their CV. You want to, there's lots of stuff out there that can help you choose between two applicants that look very, very much qualified based on what they've presented on paper. But then you go out and you look out and you see what's going on social media, and then you can determine whether one of them, displays poor judgment based on the, crazy comments that they put on newspaper articles published online or other websites, the way they respond to or personally attack others. You can gather a lot of information, but as we all know, you have to be careful about what you use if you are doing these types of searches. You don't want to kind of dive too deeply into somebody's social media if it's going to disclose protected information that you don't necessarily want to know in making your decision. For example, if somebody, maybe they have a health condition or a disability that is not obvious that they didn't disclose because they don't think it will affect their ability to do the job, but because you did this deep dive into their social media postings, you discovered it. And now you're going to use that information potentially in making your decision. You're walking into a potential ADA lawsuit if it comes out that you had access to that information. Same thing about maybe who they associate with or what religion they practice or what holidays they celebrate or don't celebrate. Maybe their class reunion page you come across. So now all of a sudden, their age, that when you shouldn't really be having that information up front when making these initial hiring decisions. The information on the internet could be completely incomplete. It could be not them. The John Smith that you found might not be the same John Smith that is applying for the job. The John Smith that is applying for the job maybe had somebody who put something up on the internet as a joke when they were fraternity brothers together 15 years ago. But as we all know, the internet is forever. And no matter how much you try to pull that information off, it always seems to come around again. So you need to be able to verify the information that you're utilizing and corroborate it if it's something that you believe is important and a fact that you're going to take into consideration in making an employment decision.
Well, I think that we've seen with a number of police officers and other public positions that you take some risk in what you post on social media. And so if you post things that are racist, if you post things that that are in support of the National Socialist Party or things like that, you run the risk of being either disciplined or terminated or not hired. The issue that we have as management side attorneys is a lot of times our employers will say, well, who's going to know what I consider, right? I mean, who's going to find out? And that's kind of where we talk about the doctrine of everybody knows everything, right? That there are no secrets in this world. And if you want to really know how quickly a secret lasts, try saying something in a municipal building. It lasts about a half second. Everyone knows what everyone knows what everyone knows. That's twice as fast in the average school district building. But the point being is that I think it's appropriate when balancing First Amendment issues to hold people accountable for their social media presence. If they say something, about the Nazis that is supportive of that, and there are a forward-facing public figure, that may certainly be an issue. But too many times we see people make decisions on hiring or retention, but mainly hiring based on what they Google about somebody without doing the underlying interviews. In addition, as Renee pointed out, and this kills me, people will put stuff on the internet that you couldn't ask about and they would never have to reveal. And Renee provided some examples. And we've seen a couple cases where people have gotten caught with the internet search they've done to make that decision. We'll talk a little bit about off-duty commentary. There is this shibboleth out there, this belief that if I make a comment on social media that's on my own time about a coworker, that there is no basis for discipline because, hey, look, I was in my pajamas in my basement talking about my coworker. And that's simply not, that's not accurate. We are starting to see, we've seen more, kind of harassment cases, primarily, escalating creepiness cases, where coworkers have an issue with each other that either gets very aggressive or gets uncomfortable by off-duty commentary or harassment. And those are clearly matters which can be subject to discipline and concern. We talked a little bit about this, the idea about password access, which we certainly don't favor ourselves. So what's our policy look like, both for electronic communications and for social media? One, just for the communications, we own the computer system, no expectation of privacy. We have the right to monitor. I will tell you a secret, if you're on the employee side, if an employee does something wrong, I'm immediately going to start to look at their emails, depending on how serious it is, because it's kind of like the part in The Incredibles where someone starts monologuing about the next evil act that they're going to do. That happens all the time in employee emails, and they just leave them behind. Renee is dealing with a case involving a sheriff in the western part of the state, and she's been reading a lot of emails, and it's amazing what people will say and can say. The personal use of the network and the internet systems at the discretion of the employer. I don't know that we have, Tricia, I'm not sure that you know of any employers that we have to have you can't use the internet for anything personal at all. That we have, because I think that's just antithetical to the work we do. But both Renee and I, in the old days, represented Verizon, where you absolutely couldn't get on the internet, and you couldn't get on either your billing page or your relative's billing page. You were fired automatically. Do not pass go. Do not do anything whatsoever. The harassment.
One of the things, sorry.
Please, yeah,
one of the things we counsel is you don't want to have a policy that you're not going to enforce. So that's why these absolutely no personal use of any system can be seen as unreasonable, because unless you're 100% enforcing that against all of your employers, it can get you in trouble when you do need to enforce it against that one person. So and then they of course are going to claim that you're only enforcing it against me because of my age or my race or my disability, or because you're retaliating against me because I made a complaint about something else. So those reasonable uses, kind of provisions or exceptions to the policy, as long as it's not violating any of your other policies like your harassment or confidentiality, and as long as it's not affecting your ability to do your job, if you're not surfing the internet 24/7 instead of actually performing the job that you were hired to do.
So with regard to social networking policies, one of the things that we talk about significantly is if you're going to post, you have to post and make clear that you're not posting on behalf of the employer, the company, the school district, or whatever. And this is again on the PennDOT case that we started out with. it wasn't clear that she was posting her own opinion. And if she was posting her own opinion, it was so derogatory to PennDOT that was an issue. This is kind of a case that we've seen in the NLRA circumstance. We haven't, I don't think, seen it at the Labor Board in Pennsylvania, but I think we're going to. So, obviously you have the right to concerted activity, to complain about your boss and your work conditions. And starting in 2010, the employer had a policy that says, look, you can't get on the internet and say bad stuff about us. You can't say anything disparaging, discriminatory, or talk about your employee situation or comments about your superiors. And the Labor Board, going back to the Obama years, found that to be unduly restrictive of your ability to engage in protected concerted activity. And so it started out with a case from Connecticut involving an ambulance company where an employee used a code for an escaped mental patient for their boss. Ha ha ha, everyone thought that was funny. And they had a handbook and a policy that strictly restricted the ability of someone to say anything bad at all. It was so broad that the board felt that it cut into their rights under the NLRA. So, of course, they posted on their Facebook page their test for Facebook use. The place of discussion, the subject matter, provoked by unfair labor practice, that kind of stuff. And so essentially Facebook has become the new water cooler. Social media has become the new water cooler and the place where protected concerted activity happens. And so the minute that Tricia or Renee or I see a policy which simply says you can't say anything bad and you can't post anything that is derogatory, we X that out because both the NLRB and the Pennsylvania Labor Relations Board will continue to start striking down those kind of situations. So Costco, I don't know who says anything bad about Costco. Look, if I need 5 pounds of nutmeg, where am I going to go but Costco, right? I mean, you can spend $500 there at any time. And so Costco's rule, don't damage the company or the reputation. This BMW salesperson, I think in Alabama, same kind of things. In this particular case, the employee posted embarrassing photos of an accident involving a Land Rover dealership owned by the same company. Never make fun of Land Rover, I think is the kind of the basis of this case. And the board said, look, these are posted as a joke. It wasn't part of the terms and conditions of employee. I like this case where the employee was terminated after calling someone an NMF on Facebook, and it was protected speech. It's kind of a significant issue. So as long as speech is focused on wages, working conditions, or unionization, not just I hate my job. If it's scandalous, it's derogatory or personal, that doesn't have the same kind of level of production.
Right, and that's part of the real focus is, was the speech, really focused on the terms and conditions of employment, or was it a personal rant about something, or did it otherwise violate other policies? For example, one of the older cases, there was somebody working as an EMT and was complaining about a coworker and said they wanted to beat the coworker over the head with the ventilator. That's not protected speech. But speech saying, they're making us work long hours and my supervisor is not treating us fairly, those types of things would be protected.
So just broadening out, bringing Tricia into the conversation, because Tricia and the Office of Open Records are on fairly familiar terms. One of the things, again, we're seeing a lot more is kind of the Office of Open Records deciding whether social media is something that is a matter of public record that can be searched, including individuals' private social media accounts. I'm just going to throw it to Tricia to just tell me when to move the slide and I'll do it.
Sounds good. So we wanted to touch on the right to know law today because I think everyone on this call either works for a public agency under the right to know law or with a public agency under the right to know law. And as Mike said, whether or not your activity associated with that agency is in their servers is no longer the calculus. And so there is a right to access to private social media accounts, private emails, if a certain test is met. So before we get to that point, just Pennsylvania's right to know law was significantly modified and amended in 2009, and it completely shifted the burden of the way this law works. And so now there's this presumption of openness. So every record of an agency is now presumed to be public. And then it's only not public if certain exemptions are met. So looking at the definition of a record, it's any information, regardless of its physical form or character, that documents a transaction or activity of an agency. And that's sort of the key language here. And it needs to be created, received, or retained pursuant to the law or in connection with a transaction or business activity of the agency. And so cases that have challenged this, you have public employees saying, well, I sent it from my personal email account. You can't access that. And the courts and the Office of Open Records have specifically rejected that approach. It's not where the record is located, it's what the record is about, right? And so if that record has anything to do with a transaction or activity of the agency, then it's considered a record under the law and may be subject to access unless it meets one of the exemptions. And so, looking at what our records, it's all of these things, and that includes social media. So we often receive right to know law requests now that are specifically asking for anything discussed in social media accounts. And, as the agency, we have an obligation to have our board members, our employees search their social media accounts and determine, whether a responsive record exists. So moving to the next slide, Mike.
Yeah, I just want, before you move on. So here's what we've seen. We've seen mayors or superintendents who have a Facebook page that they use for business, right? That they do school district work on or borough work on. And the nexus between their private Facebook page and the amount of work they're doing on that to announce borough events, to announce school district events, to DM with people or whatever, that's apparently called direct message, I'm not sure. And so on and so forth, converts that otherwise private page into a discoverable event under the statute.
And it can even happen in an unintentional way. We do often see our elected officials sort of intentionally conducting business over their own social media, but also you'll have people that reach out to elected officials, to school employees, into their own social media accounts in a private message saying, oh, I just wanted to ask you X, Y, and Z. If it's about that work at the public entity, even if the public employee didn't initiate the contact, it's still potentially accessible under Pennsylvania's right to know law. So just to touch on how people can get access to this information, it has to be addressed to the public entity. It has to seek a specific record and has to describe that record with sufficient specificity in order for the school district or the agency to be able to conduct a search. We don't have to respond to requests that don't make any sense. We don't have to answer questions under this law. We don't have to explain ourselves. We don't have to do legal research. But if somebody requests something that's in your social media account that is a transaction or activity of that agency, we might have to evaluate whether or not we need to turn it over. There's about 30 exemptions in the right to know law. We put about half of them up here for you. So there's many different ways that these records might not need to be turned over if they exist. In a lot of the cases, dealing with union grievances, that kind of information, there are exemptions that protect that information from having to be disclosed and to keep it private. Another piece of this, as Mike mentioned earlier, is Pennsylvania has a constitutional right to privacy. And so there is going to be information, contained within some of these records that might technically be a record of the agency that's simply not disclosable. And that information can then be redacted pursuant to, there's the 708B6 personal information exemption, and you combine that often with the right to privacy. So even if, a communication concerns in part business activity, the piece that you might be revealing, personal information about yourself could be redacted and protected so that not everything needs to be turned over. And this is just, some other additional things that might not need to be disclosed under the right to know law that keeps some information private. I think the main thing that we wanted to convey is that anytime you're dealing with a public agency, anything, no matter where it is, it doesn't have to be just on that agency's database. If it's in private personal accounts, if it concerns that agency business, it's technically a record under the right to know law. And so it might be subject to access, subject to any exemptions. Something to keep in mind.
So, kind of broadly, we wanted to sketch out kind of some of the social media concerns we have, both under the Fair Labor Standards Act, under general policies, First Amendment issues, as we indicated, and also kind of the length of where, as a public entity, you can get access to people's social media where they use it for official business. So, Mr. Holman, I'm going to turn it back over to you. We were asked to finish by 7 and 7:01. We've exceeded our time frame by a minute. And so if anyone has any questions or anything we can do to kind of do a rocket tour through social media, please let us know and we'll be happy to deal with it.
Very well. Thank you. We really thank you for your presentation this evening. And certainly if anyone would have any questions, feel free to raise your hand electronically or otherwise, and we will try to get through the questions that you may have. We understand, again, with our meeting being an hour in length, if anyone has to exit, they are certainly welcome to do so as they need to. But if you have any questions, and since you're willing to entertain some, we could go ahead. I'd ask if you have them to raise your hand, and I'll actually have Kate reach out to facilitate that process.
We're equally happy to hear about good emails you've read. So, I mean, yeah.
I see that Scott has his hand raised.
Yep. Thanks for doing this presentation. It was great. My question is about the right to know law and the discussion about how records that are not in the custody and control of the agency can still be discoverable, like someone's social media account. But in practice, how would you go about enforcing that as an agency? How would you, it's just the honor system, asking an employee turn over everything that you have that's private that we can't check?
Yeah, so Scott, that's a great question. And I'm going to turn it over to Tricia, but I'm going to tell you, there is nothing better than asking elected officials who pay your bills to search their private email accounts, have them search it, turn it over to you, and then pay your bill for reviewing their private emails. It's a real trick. It's a lot of fun. It's one of the most enjoyable parts of my job. Go ahead, Tricia.
So Scott, you said, custody and control. So under the right to know law, it's records in your possession, custody, and control. So the records the district actually has are the ones in their possession, right? And the ones that their employees have, but they don't, is where, custody and control comes in. So the practice I usually undertake is if I'm, think a request might include records that somebody else has in their personal accounts. Our practice is to send, that employee or official an email saying, we've received a request. Here's what it is. We ask that you conduct a search of your own personal accounts and report back and affirm for me whether or not you have anything. And I also tell that employee that if there's an appeal, that employee will be required to attest in an affidavit under penalty of perjury that they conducted the search and that it turned up XYZ results. And the right to know law requires that. They require those, affidavits to be submitted during an appeal process, not during the initial request process. And so that's how we handle it. And so far, the Office of Open Records has accepted that process. They, do not mandate that an employer personally search those personal accounts. Probably for, the concerns we discussed earlier. And so we ask, our employees to do that. And then if there's an appeal, they'll have to attest to it and we go from there. Does that answer your question?
Yeah, it's good.
Generally
And
speaking, I try and get everyone on realistically to do all of their work through a server that the school district or the borough or the township owns, because it makes life a lot easier. However, if you are used to doing your work through that social media site or that Twitter site, some elected officials are, man, it's tough to break the habit.
Any other questions? I'm looking for hands being waved at the screen. I see UNHCR. You have to unmute yourself.
My name's Tom Kellner. I'm a labor arbitrator out of Western Pennsylvania. And when I signed on to Zoom, my daughter works for the Human Resource Refugee Council. For some reason, it registered there.
We often get people from The Hague, other places like that, attending our speeches. It's not unusual.
Just a general question. Are you still finding that the NLRB interprets the protected activities interpretation, I guess, as extremely broad?
Well, it depends on who's the president is. Realistically, during the Obama administration with Obama appointees, yes. During the Trump administration, not so much. And so it kind of waxes and wanes to a certain degree. But the reality is that as Facebook becomes the method of communication between employees about issues in the workplace, and that does happen, or tweets or texts or whatever, the reality is that the boards, both the Pennsylvania Labor Relations Board and National Labor Relations Board, has to adapt to the technology and kind of broadly look at those complaints. The difficulty is, like anybody else, taking 140 characters in a tweet or whatever, and taking kind of unspooling the private complaints about your own issue with whatever's protected, right? They pay too little versus I hate my boss personally, and so on and so forth. So yeah, no, again, I think it expands and tracks a little bit depending on the administration, but the general thread is there. The biggest difficulty is, the fact that when humans communicate, they don't do it in a linear fashion, and they do it on technology, and it's difficult to kind of unspool that, if that makes sense.
Thank you.
Any other questions? I see Mary Teresa.
Yeah, I just maybe a comment and a question in terms of how it's affecting your practice. It just seems that everybody, employees in the workforce, have used email and communicated via email, but there was a time when people actually physically went to offices and worked in the same building or in the same floor. And they might walk down the hall and they might discuss a situation in an office in person. Now, because that seems to be becoming so rare, and because of COVID and everyone working remotely, it seems to me, I would guess that a lot more is being put over social media, over email, than otherwise would have been pre-COVID, just because, again, people could have conversations in person. So I'm just wondering if you're seeing an indirect effect of the remote workforce in terms of the number of cases or the volume of email that you have to go through when you're doing a search, because everything is, so much of the workforce is remote these days. Just wondering how that's impacted this whole issue of social media.
Well, I will say that you hit the nail on the head there, because people are communicating more electronically through instant messaging or texting and emailing, as opposed to having those face-to-face conversations. We find that we have to do a lot more counseling to our employers, to clients, particularly at the outset of potential litigation, to make sure that the individuals are preserving that stuff that they wouldn't otherwise have available. Because when you're just chatting informally or coming up to the HR department, there's no records that you need to preserve or search. But now we have that whole universe of stuff. So we're seeing more issues with discovery and document and communication preservation. And we have to be a little more diligent on the front end to make sure that they're collecting that stuff, and that we're spending a lot more time having to review it, particularly once we get into litigation. And I know that Tricia and I have a large client that we are doing a lot of work for, that's all how they communicate. So every, what maybe 10, 15 years ago would be a quick PHRC response now turns into a 30-day review, and trying to piece together from the different, Slack messages and messages on records and how they communicate back and forth. And we're trying to piece together the timeline and recreate what actually happened going through these thousands of messages. So it definitely has affected the way that we practice law and how we counsel our clients. So
let me just kind of three avenues there. First, for all you arbitrators on the call, social media and electronic communication will guarantee that there will be cases to take you through your retirement and beyond, because Mary Teresa is exactly right. There's a famous saying from David Lawrence, the former governor of Pennsylvania, who said, you should never write what you can say, and you should never say what you can wink. There's always great wisdom in the unsaid word. And so Mary Teresa is right. Because of all of this communication, again, 15 years ago, if there was a confrontation at work, it was like Rashomon, everyone saw something different, right? So everything saw this or that or whatever. Now you got the email. Now it's just a Rorschach test. Who sees what in the email or the text, and what did it mean? But it's permanent, and if you're in front of a fact finder or you're in front of a jury and the email is behind you on an easel, don't pay attention to that email. They didn't mean it when they said it, right? Pay attention to me, or pay attention to my witness. And it's very difficult to deal with. So yeah, Renee's exactly right. We're seeing a lot of that. And I will tell you this, for employers, especially for elected officials, it's like unlearning a skill. You're elected because you communicate with people. You like communicating with people. You may hate people, but you like communicating with them. And so you end up communicating over and over again on different circumstances. And then you get to be an elected official / employer, and you got to shut up, right? And that's just antithetical to what they do. So Mr. Holman, myself, if I could throw myself in front of people's iPhones as I see them text each other during meetings, it just kills me, right? Has anyone heard of a caucus? An executive session perhaps? But that's what happens, and it is becoming a continual problem on the employer side. So trying to get people to unlearn that skill. Look, again, I refer to my daughters because they're a wealth of comedy gold. And I will tell you that the chances of them writing a letter, right? Sending a postcard, doing anything that requires anything but electronic access are kind of slim and none. And so we're creating great records. The question is, are we all, I'm now wearing glasses. I didn't used to, primarily because I'm a labor and employment lawyer. And I got to look at a lot of emails.
Okay, I'm looking through. I see the Hague has his hand raised again. I don't know if you got another question. Nope. Oh, he's on mute.
No question.
No question. Okay, sorry. I saw the little emoji in the corner there. Anyone else have any other questions? Okay, great presentation. Mark, I'll bring it back to you.
Very well. Thank you all again. I would like to thank everyone for their attendance at our meeting. I will throw a shameless plug in that we will have our next meeting on March the 1st. It will also be a virtual meeting. I would like to extend a huge thank you to our speakers for today. In addition to that, I would also like to thank the representatives from LERA National for their assistance in helping us to get this meeting off the ground as well. And with that, I would like to say good night and thank you, and be safe and watch out for the snow. I heard it's coming.
Thank you, guys. See you.